Hi everyone. I'm hoping you can hear us. There is a chat function, so if anything goes wrong and suddenly you can't hear us or see us, then just drop something in there and we'll spot it. I'm Eleanor. I'm one of the barristers here at 42 Bedford Row.
And I'm Laura.
We are going to talk to you today about witness statements generally.
Yeah, we chose this topic because I think we're all PI lawyers here, and many personal injury and or clinical negligence cases rest on issues of witness credibility rather than issues of law. The law is often a fairly settled matter, but it's down to the evidence. So we talk about witness credibility, I've written here, that's linked to, but not the same as honesty, although that is obviously also a big issue in all of the cases. And truthfulness is clearly relevant, although a witness can be honest but mistaken. So we're going to be looking at witness statements, and hopefully the important things to cover and pitfalls to avoid. So statements, obviously your starting point is Practice Direction 32, which sets out all the formal requirements, which will be familiar to all of you, the heading.
No doubt, we're all perfect.
Heading, the information at the top right corner.
I think a lot of people do tend to forget that, but it is in the CPR, so you have to put it in that little header on the top right with the name of the claimant, etc. Do make sure you include that.
Yeah, if this is not familiar to you, head to paragraph 17.1 of PD 32, and it's got it all listed out. We're going to cover the key issues later on, so to do with language, etc. I think main thing to flag up here would be, it should be in the witness's own words, and also to indicate which statements are the witness's own knowledge and which are matters of information and belief, and then the source of any matters of information and belief. This can be relevant. Obviously, we've got the claimant's own evidence, but also look out for evidence from the other side as well on this point, particularly say if you've got an employer's liability case where you've got one of, well, particularly if you're a claimant, but one of the defendant's witnesses talking about, they usually bring someone in who's talking about what generally happens, what the safety standards are, because if they haven't indicated whether this is their own knowledge and belief or whether this is coming from somewhere else, that can be an issue. It's a mandatory requirement, so if they fail to set this out, it may be that, in fact, if you look carefully at their statement, what they're doing is giving expert evidence for which they don't have permission, and that can be a way of problematic for them, hopefully. That said, obviously, everyone, when we're talking, we talk about facts, but we also do give our opinions when we're simply recounting an event. So I've given some examples in this slide from a case involving a road traffic accident. It's a High Court decision, the case of Marcel, Bella and Hayden. The claimant had taken out a personal accident policy on the life of one of their employees, who then died in a road traffic accident. And the issue for the court was whether the defendant underwriter was liable to pay out on the policy, or whether the employee had deliberately exposed himself to an unnecessary risk because he was driving while under the influence of alcohol. And this Mr. Brarup was a witness in the case. He had actually been a passenger in the car with the claimant, and he gave a lot of evidence, a lot of which was opinion evidence. So I've set some of it out there. He said that the deceased appeared a quite sober man. That was his opinion. He could hold his drink. He said that on setting out from the pub, the deceased appeared to be all right. He was not, in his opinion, the worst for drink. He drove perfectly well. He estimated his speed at 50 miles an hour. He thought it was possible that the skid was caused by wet or ice on the road. He thought the deceased had acted properly to correct the skid. He gave opinions on his reaction times. So all of those sorts of opinions will be very familiar to anyone in a road traffic accident case, because statements are full of them. And the court said, as it was raised that this was all opinion evidence, the court said that actually this is all admissible opinion. Ordinary witnesses aren't strictly confined to giving evidence merely of facts, but factual evidence, or an ordinary witness can give an opinion, so an impression that they have drawn from the facts that they have observed, and that is admissible, although the judge will decide what weight to place on that opinion. So in this case, the fact that Mr. Brorup had also been drinking with the claimant from 5:30 till 10 at night, meant that the judge decided that although this was Mr. Brorup's honest opinion, it wasn't necessarily something that he would give any great weight to.
Enough. One thing that it's important to be sentient of in this vein is hearsay evidence. We see it cropping up all the time because obviously our witnesses, or the other side's witnesses, want to report things that they've heard from third parties, things that are outside their own first-hand knowledge. Going back to the actual legal side of it, as we've covered already, you have to identify what the source of your knowledge or belief is, and if it's not your own source of belief or knowledge, you have to identify who you got that knowledge from. That is a mandatory requirement, as Laura said. It's must, not may, so it has to be done. If the statement contains any hearsay, the best thing to do is to name the individual that said it, because that gives the other side the opportunity, if they want to investigate that, to go and speak to the person involved, to cross-examine them and understand what their role in this is. If the witness can't identify them directly, they need to give as much detail as they can. So the specifics of where they were at the time, what the circumstances were, what the person looked like if they actually don't know who the individual was. Imagine, for example, you've got a sort of police officer at the side of the road. You don't know the police officer's name, but you can describe the circumstances in which you overheard that individual say something. And that's the sort of detail that needs to be included if you're going to rely on that type of hearsay evidence. I mean, we all know that judges take hearsay evidence with a pinch of salt anyway, but this sets a witness in the best stead they can be in to be able to rely on that kind of evidence. If you don't do that, there are countless cases that I can think of where the evidence has been disallowed because they haven't specified who the source of that evidence was. A sort of interesting case, maybe just because it's a sex scandal from The Sun, that's come up recently is this case of YXB and TNO. So this was a Premier League footballer who did something dodgy in a hotel, and there was a potential for a Sun article coming out, and he applied for an injunction preventing that publication. The only witness statement in support of the injunction came from his solicitor, who somewhat problematically spoke about the fact that publication of this would be damaging for the claimant, for his reputation, would be harmful to his partner, would be problematic to his child. But she didn't state that she had spoken to the claimant and that the claimant had confirmed that. She also said that it was remarkable for the other side to suggest that publishing this material wouldn't be problematic. And again, the judge took issue with that, not because she didn't specify the source of the information, but because that is effectively a legal submission that snuck its way into witness evidence. And that's another thing we'll go on to talk about in a second, which is an absolute no-no. All of this was contained in a witness statement with the usual paragraph saying all of these statements are derived from my own knowledge, or I state where they aren't. And she obviously just failed to do that. And in those circumstances, the injunction failed. So it's something to definitely be aware of. If you've got hearsay evidence, treat it really carefully, because there are rules you've got to comply with.
Now, before we move on from hearsay, we have actually just had a question for you. about hearsay.
Great. Sure.
I had a client at trial who didn't have first-hand knowledge of a matter and stated in his witness statement that the council's records show he was a council employee, and the judge queried how he believed that the records were correct. Do you have any tips on how to deal with matters where the witness is relying on computer system records?
So, I mean, a lot of witnesses are going to be relying on it's always such vague terminology. It's either systems or our computer system or the way our system works. And frankly, none of us are IT specialists. So we just have to sort of take it as read that they're talking about an internal process, piece of software, whatever it is, that works, that either records employees in this case. I think it's probably unlikely, in the absence of evidence to the contrary, for a judge to assume that what a witness is saying is wrong about records.
Whether they had a copy of the record, because I think there is a rule in the CPR, I'm just trying to think what number it is, that if you have a document, it is assumed that it is correct unless the other side queries it.
And I think that's right, because I mean, so much is put before the courts and it's just sort of taken as accepted, unless before the trial, either in witness statements or through correspondence, the other side flags up that they take issue with it. So I haven't seen myself any instances where straight off the bat, unprompted, a judge has said, what's the
says the document was attached. The problem was the person who made the record was no longer an employee of the council. I'll see if I can always email you later, because I'm sure there is a rule within the CPR that unless the other side have queried the document, that it is
taken as accepted. It would be a counsel of perfection, I think, to require any party to produce the actual drafter of a document in every case, because most witnesses are adopting to a degree either established internal systems or, for example, if they're a local authority employee and they're reading out records for a slip and trip case, say, you're not going to have the person who wrote those records in every instance. You're just going to have someone who's got a good working knowledge of that system, and they'll say, yeah, this is likely to be right. And unless the other side has evidence to say that's not right, I think that should be okay in most circumstances. But yeah, Laura's going to get on it. So thank you, Jenna. That's a good question. Keep them coming if you've got any more. So one aspect of writing witness statements that I think vexes certainly quite a lot of people that instruct me is the situation that you have when you've got someone whose first language isn't English. The rules have changed fairly recently, and that I think is the source of confusion. So I've set out 3 sections of practice direction 32 there, which make it extremely clear that if you've got a non-English speaker as a witness, you have to draft the witness statement in their own language. So 18.1, you'll see that whilst the witness statement must, if practicable, be in the intended witness's own words, it then goes on to say it must in any event be drafted in their own language. So that is non-negotiable. That's for reasons I can't fathom, then repeated at 19.18, just in case we've missed the message. And then there's a further repetition in 20.1, but that relates to the statement of truth. So the statement by the intended witness in their own language that they believe the facts in it are true. So it's got to be the body of the statement and the statement of truth that are drafted in the first language of the witness. You then get to the difficult scenario where you've most likely got a situation where you speak English as your first language. You don't have anyone in the office who speaks the language of the person whose statement you need to take. What you're going to need to do there, even though it's time consuming and expensive, is go to a interpreter's service where they can take the statement from the witness in their native tongue and then have that translated into English. I think probably the best way of going about that, as I've said there, is to prepare a kind of list of questions, topics, so you make sure every issue from the pleadings is dealt with, and it makes it so much easier for the person who's drafting the statement just to go through each of those and make sure that the witness is given an answer to those, and then they can clear it up, tidy it up, and have it translated into English, sent to you. I can't count the number of cases, particularly lower value cases, where it's been done the other way around. So the statement has been taken in English, presumably because a pro forma is being used, and most of the statements are similar, for example, for a small claim RTA or even a small claim or even an RTA fast track. That's been taken in English and then it's been translated into the language of the person whose evidence it is. That's not acceptable. And I've had a few witness statements thrown out. If you find yourself in a situation, maybe you've taken a file over from someone previously and that's all you've got, you do have to throw yourself on the mercy of the court. I have had that done before. I've arrived at court and asked the interpreter to read the statement out to the witness in their native tongue to make sure that they're happy with it. And then I've asked the interpreter to read the foreign language translation to make sure it's a completely accurate version. That's not ideal because it doesn't always work, but if you're really stuck, then you can do that as a last effort. But best to avoid that in the first place, really, and just make sure you've got a statement in their native tongue, and then you can have it translated into English afterwards.
We've got a question there. Does the translation service need to be a court authorised translator, or can we use any translator of our choosing?
So as far as I know, there are no specific rules about who can do the translation. I think it's whoever is going to be cost effective and available and good at it. There is a difference between translating statements for someone whose first language isn't English and having a statement certified for someone who can't read their statement, but that's for a reason other than the fact they don't speak English, and that's actually our next slide. There are specific rules about who can do the latter, but when it comes to translating statements, no, I haven't come across any specific rules about who that has to be. I think you just make a judgment call as to who's available and who's going to do an okay job.
And there's also another comment: non-English in respect of deaf witnesses, i.e. British Sign Language, where syntax is wholly different to spoken and written English. The interpreter is not only interpreting but also reconstructing the statement into standard English. It may depend on your witness though, because if they are able to read and write, you could make the statement by putting the questions in writing and asking them to just
fill in the gaps. Yeah, absolutely. I've had quite a few cases involving deaf witnesses, and that's only at the time we get to the court stage, so I haven't been involved in them drafting their witness statements, but certainly I appreciate that there is a different process as compared to a straight translation from one language to another. I know that it's a slightly different system, but I think, as Laura says, the way to do that would just be to do it all via typed documents, preferably. If that's not possible for whatever reason, if they're not computer literate or you can't get them in a room sitting down to sort of go through the documents together in written form, then I think the court would be sympathetic to the fact that there's going to be a certain gloss put on the signed language by the person who's putting it into written form.
Because you have got the new Practice Direction 1A, which provides for the court being accommodating to vulnerable witnesses, which would include deaf witnesses.
Yeah, absolutely. So as I was saying, coming on to this different provision, it's often, I have found, confused with the rules on foreign language statements. I think, again, that's born out of the fact that the rules changed fairly recently. They used to be different, and I think a lot of people are still eliding the approach that you have to take to foreign language statements and statements for people who can't read or write at all in any language. So if you have an illiterate witness, the provisions are in Practice Direction 22.3.A. This is where you need an authorised person. So it's someone who is permitted to administer oaths. It's the person who previously, under the old rules, you would have needed to go to get a certification that the language translation is proper. So with the illiterate witnesses, the rule is that the statement of truth has to be followed by a certificate made by an authorised person. And an authorised person is defined at 3A.2 as a person able to administer oaths and take affidavits, but need not be independent of the parties or their representatives. So it can be someone within your own office, it can be you as a solicitor doing it on their behalf. And what the authorised person has to do, and this is set out at 3A.3, is to certify that the document has been read to the person signing it, that the person appeared to understand it and approved its contents as accurate, that the declaration of truth has been read to that person, and that the person appeared to understand the declaration and the consequences of making a false declaration, and that the person signed, or if they can't write at all, made their mark in the presence of the authorised person. So those are the formalities. There's a very helpful form set out in Annex 1 of the Practice Direction, and that literally captures everything that the certificate needs to cover. So if you just copy and paste that, then you won't have missed anything crucial out. So it's not as common at all, but if you do have a witness that can't read or write, go to Practice Direction 22.3A. If you've got a witness who can't read their statement or can't write in English, but can read or write in another language, this isn't the section for you. Then you have to look at the section that we covered in the previous slide.
And just going back to that previous slide, we've got another question here. With most cases being fixed costs, is there a danger firms will stop taking many cases on due to the increased cost of a translator? Would this disbursement be recoverable? I think the answer is it's not recoverable because it's to do with the claimant rather than the claim.
Yeah, there is a helpful provision that you can sometimes rely on under the fixed costs rules in respect to disbursements, where a particular feature of the dispute means that you've incurred a disbursement that isn't contained in the normal list. Unfortunately, there are authorities on the difference between a feature of the dispute and a feature of the claimant or the defendant, whichever it may be, and that is not a recoverable disbursement. I appreciate entirely, and you're probably right, that may put some firms off taking these cases because it's effectively a cost that has to be swallowed and can't be recovered from the other side. And as far as I know, there's no way around that.
No, and yeah, if that's going to wipe out basically profits because we're on such fixed margins anyway.
Yeah. They're not
that may be
cheap,
the effect.
these translation services. I think most of them, I've seen bills running to the thousands for translating witness statements, but then in some cases you've got translators who are translating like the medical report, for example, and that can be extremely expensive, and that would completely wipe out any costs that you recovered. So I appreciate entirely that it is a very difficult scenario for firms to be in. Yeah, absolutely.
This is proving a controversial topic. We've got more questions. Although you can sign as the client's own solicitor or get a colleague to, can this cause any issues re credibility of the statement in your experience? Does the irrecoverability of this as a disbursement apply even when the witness to statement needs to be translated as not the claimant? And someone's saying that they did recover this in 2018-19. Has the law changed?
So first of those probably relates to the illiterate witnesses, because that's the only type of statement that needs a certificate from an authorised person. No, it wouldn't affect the credibility of the witness to have you be the authorised person, because all you're doing is confirming that they understand their witness statement and the statement of truth. That's something that's well within your remit. Frankly, it's what all solicitors will be doing with their clients anyway, but this is just an extra safety layer that's been enshrined in the CPR to make sure that people in this position are protected.
And in fact, Practice Direction 382 specifically says an authorised person need not be independent of the parties or their representatives. So it could...
It's obviously envisaging a scenario where it's going to be you as the solicitor.
Or someone within the firm.
Yeah, absolutely. And then on to Emily, your second question, does the irrecoverability of this as a disbursement apply even where the witness whose statement needs to be translated is not the claimant? I mean, so if it's a PI case, you're likely going to be in a Quox scenario anyway. So unless there's a finding of fundamental dishonesty, you're not going to be getting your costs at all. If we are dealing with a case where the claimant actually has been made to pay costs, the same rules apply to defendants as they do to claimants when it comes to the fixed costs disbursements.
I think it probably means a claimant witness. So
I see. So someone supporting the claimant. Yeah, again, I don't think it would be recoverable as...
Because it wouldn't be a feature of the dispute that the witness
doesn't speak English. It's a feature of the witness.
Yeah.
So I mean, it's always worth a punt. These are worth making as arguments, but I don't see them working ever. So yeah. And then Mutaha said, you recovered this in 2018, did the law change? Lucky you. No, not as far as I know, and most judges won't allow it.
Yeah.
Unless they haven't read the
They'll say it's second
fixed costs regime.
Yeah.
So yeah, you got away with that one, but not usually. Right.
Oh, are medical records in a different language a feature of the dispute?
I have not come across a case where medical records have been translated for the benefit of the court. I have to be honest, every case I've done, the medical records have been in English. I've had cases where the medical report, as in the Part 35 expert report, has been translated from English into the language of the witness. That again hasn't been recovered, but I haven't come across, unless you have, Laura, any cases where the notes have been in a foreign language.
I've had one where it was we had some hospital records from Germany, but I don't actually know, and I wasn't asked whether we would be able to recover it, so I don't know what happened in that case with the solicitors.
Yeah, I think it would certainly be worth arguing that this is a feature of the dispute, because the records are documentary evidence. They're not the witness themselves not being able to speak English. So I think you've probably got an arguable point there. give it a go and see what happens. It sounds like you might have a bit of a difficult job of it, but it's worth arguing for it and seeing, because yeah, as we've said, these fees can be huge. If you're getting medical records translated, that's insane. That's going to be thousands. Yeah, absolutely. So I think that's all of your questions. We're going to oh, that's me again. Defects in statements. So just something to bear in mind. It's only a small point, but it's potentially a serious one. If the witness statement doesn't comply with either CPR 32 or Practice Direction 32, and there are a lot of formal requirements in Practice Direction 32, there's at least 2 or 3 sections where you have to tick every box in terms of what it looks like and what it contains. If it doesn't, it can be the case that the court refuses to admit it as evidence, and or if they do allow it in, they won't allow the costs associated with preparing it. So just bear that in mind. It's an important point. I think a lot of people think, look, as long as the substance of the evidence is there, then that's fine. But that's not always the case, and a proper black letter law judge will pick up on it. And if the defendant or your opponent, if the defendant makes a big deal of it, then it can well be fatal to the witness's claim. That said, the rules, I mean, anyone who's done any small claims cases will know that it's a bit of a wild west in terms of evidence. Although the strict rules of evidence don't apply, it does depend largely on the type of judge you get as to whether they'll be happy with a statement that's hopeless going in and they think, look, we're all here, might as well get on with it, or whether you've got a stickler who says, look, I know that the strict rules of evidence don't apply, but this just doesn't even vaguely cut it. And that is sometimes the case with a foreign language statement, because they're not happy that the witness understands their own evidence if it hasn't been translated properly. That's one of the types of cases where I've seen a judge on the small claims track say, no, not having any of it. So I think you can get away with more the less the claim is worth and the less complex the claim is, but just be mindful of the fact that the evidence can be struck out if anything is substantively wrong with it.
I had another question. What if the client can give oral evidence perfectly well in English, so that you can take a statement from them and draft it, but would struggle to read the drafted statement, so would need the statement read to them? Would this be a PD 22.3a situation, or would it require taking by a translator?
So the wording of Practice Direction 22.3a is if someone cannot read or understand their statement other than by reason of language alone, then you go to that bit of the practice direction. So this scenario that you envisage here would not fall within that remit, because the reason why they can't read a statement that has been drafted for them is because that's not their first language. So we're not in a 3A situation. It would fall under the normal rules of Practice Direction 32. I think it's a judgment call. If you've got a client who's saying, if you give me this statement in English, I'm not going to be able to read it, you need to take the statement in their first language and have it translated. If, on the other hand, you've got a client who can read and write in English, but doesn't feel confident giving evidence in court in English because they're under pressure and it's a high pressure environment, that's absolutely fine. That happens quite a lot. Yeah, super common. Get an interpreter in that scenario, but it's fine for them to be affirming their statement in English because they've told you that they can read it. So if they feel more confident giving the statement in giving their evidence in their first language, then that's absolutely fine. It doesn't cause difficulties. We see it all the time. Right. I think we're safe to move on to the next one. Oh, yeah. Sorry.
You kind of put all of yours right in the middle.
Yeah, that was very silly. Should have spread them out a bit. Okay, so this is a case called Mansion Place Limited. It's actually a commercial case, but it sets out a very helpful to do and not to do guide of what a factual witness statement should include. It's actually a summary that builds on an earlier decision, which is JD Wetherspoon PLC and Harris. That gives a very detailed breakdown of what statements should include in the general principles that underline witness statements. So if you really need to do a deep dive into this, go to the Wetherspoon's decision. But this is a very handy aid memoir if you're just looking at it briefly. So we've got those bullet points there. They are true for any type of statement that's being drafted, whether it's commercial, PI, ClinNeg. The first one is fairly self-explanatory. So if they were permitted to give that evidence orally, it can go into their witness statements. The second point, cover the issues, but only the issues that the person who's relying on the witness statement, so either the claimant or the defendant, doesn't have to be the witness statement maker themselves, but whichever party is relying on that statement, it has to cover the pertinent issues. And I know Laura is going to come on to talk about this. It's so vital that the statement covers all of the live issues in the case. So look at the pleadings and make sure that it covers those issues. That said, don't go beyond those issues and include irrelevant stuff, because it will just frustrate the judge. Don't provide any commentary on documents in the trial bundle, which I see all the time. That's not the witness's job, that's counsel's job in submissions. Don't quote from documents in the bundle. The judge can be taken to those in submissions if they need to be. Don't engage in argument, either sort of argument as we know it in layman's terms or in legal argument. That's not the place for that to happen. This is an interesting one. Don't deal with things because they arise in the course of a trial. This will only crop up if you've got a situation where you've got protracted litigation and someone's created multiple witness statements over time. And the temptation is always to kind of add in things that have been going on in the proceedings and deal with them as part of the witness statement. That is a no-no, according to Mansion Place, so don't do that. As Laura mentioned earlier, don't include opinion evidence. It's really difficult to know where the dividing line between opinion evidence and fact is. That's why there's this carve out. So where it's necessary as background or context, or in order to give a coherent explanation of what the witness wants to say, then the witness can give opinion evidence. We looked earlier at that Mr. Brarup scenario. He was allowed to give all of that opinion evidence because it was useful background to the relevant issues in the case. And then finally, a sort of slightly less strict one. The rules aren't supposed to be applied so rigidly that in doing so you lose the sort of proper meaning of the witness's evidence, and if they need to be relaxed so that the witness statement reads properly, actually gets the point across, and that allows the judge to deal with the case justly, then they'll allow it. So it's not as strict as it might appear from that quite forceful list earlier. You again? So something that does happen, it's happened in a case that I have done, and it's usually dealt with either at the beginning of a trial or as a preliminary issue, for example, a PTR, is to have part of a witness statement struck out because that part of the witness statement offends any of the principles that we looked at in the previous slide. There are two provisions in the CPR that effectively allow that to happen. So 32.1, 32.12. And there are examples. Oh, I need to go back. And of course, now I can't work out how to go back. Have you got the little arrows? Again. Yeah. Yeah, there it is. Sorry. There actually, topically, was an issue like this in the Wagatha Christie pre-trial review. So Rebecca Vardy applied to strike out part of Colleen Rooney's witness statement for a variety of reasons. One, because it contained stuff that was going to be in the trial bundle. Two, because it effectively gave commentary on that documentation. Three, because it was irrelevant. Four, because it was hearsay. And five, because it was trying to introduce issues that effectively weren't pleaded. And most of that application at the PTR was successful. The judge allowed in anything that he thought was genuinely Colleen's belief, even though that sort of strayed into opinion evidence, because he thought it was relevant to the issues in the case to understand what her true belief at the time, and at the time of the trial as well, was. But he struck out a lot of, I mean, it was huge, it was like 66 pages long. He struck out a lot of it, particularly because it just decided to copy and paste lots of WhatsApp messages between the claimant and her agent, so not the person giving the statement, and then comment on those, which is obviously a job for counsel, not a job for the witness. There's quite a good little quote in that judgment, which is taken from an earlier decision in William and Wandsworth LBC. And the judge in that said, witness statements are a proper vehicle for relevant and admissible evidence going to the issues before the court, and for nothing else. Argument is for advocates, innuendo has no place at all. So I think he's having a bit of a dig, particularly in circumstances where this is two slightly witchy people trying to get at each other through witness statements, and that's not allowed. So that's just a little fairly recent topical example of where that has happened. Finally, Laura, over to you.
So I've just listed some common errors. So these are the sorts of things that come up at trial when you've got your witness being taken through their evidence, and there can be problems. So first, consistency. When you're writing the statement, always remember your witness is going to be cross-examined, potentially at length, particularly if the other side is challenging honesty. So if it's an FD case, on any inconsistencies between the documents in the bundle, including what's written in their witness statement, the CNF, what they've told the experts that's recorded in the medical reports, what they've told their doctors that's recorded in the medical records, HR records, everything. So when you're writing the statement, be familiar with those documents and what's said. If the client is now saying something different, query it with them, ask them, is this actually what you're meaning to say now? Why is this different from what you said before? And address it within the statement. Don't leave it so that the first time anyone raises it is the other side's barrister in cross-examination. Because if there are inconsistencies,
they're gonna jump.
They definitely will.
And it throws a witness off so easily because they don't think they're going to be cross-examined on the CNF. And all it takes is a line in the witness statement to say, this was prepared really early on in my claim. I may not have given all of the information to the solicitors that they needed. I haven't seen this document since, except for these proceedings.
They've never seen it before the trial. So
exactly.
They're like, well, I don't
what
know.
Is this?
Yeah, well, that's what my solicitor said. So just, if it was prepared on the basis of a 2-minute phone call and the solicitor took down the main gist, just say that. It's better that it's said in the statement than that it's something that the witness is confronted with in the box.
Yeah, I think there's a tendency to think if I don't mention a problem, the defendant might not pick up on it.
They will.
They always do. and it will throw your witness off immediately. So just deal with it head on. If there are inconsistencies and they're giving different evidence in their statement, just explain why and move on.
In fact, I've been at a seminar that was aimed at defendant lawyers, where they were saying, right, if what you want to do is prove people FD, and one of the best places to start is the CNF.
Yeah,
because it's replete with errors.
always.
Everyone.
Yeah, absolutely. And yeah, they go through. I mean, that's what defence counsel, I represent defendants as well, and that's what we do. We go through the records meticulously. We pick out anything that's inconsistent and we put it to the witness. And if you've dealt with it in statements, it just really takes the heat out of it.
The other thing is recollection. We all know it, recollection does worsen over time, and particularly if a case has been going on for some years. The client may well have forgotten what their initial symptoms were and the initial severity, because they're so used to the constant pain that they're in at the moment. So if it helps them, let them see the other records before you have the chat about the witness statement, so that they can refresh their memory. Other thing, Eleanor's touched on it already, completeness. Frequently the statement will be incomplete. Make sure that you check it against the particulars of claim. Look at all the allegations of breach. Have you covered them? Make sure it addresses causation. Make sure you go through the schedule of loss and make sure that every item on that is addressed. Because if it isn't, the judge may well not give permission for that to be covered in chief, and then all the defendant has to do is not cover it in cross-examination, and you've got no evidence on it whatsoever, and they win. They win.
Yeah, absolutely. It's really key. I've seen quite, and it's always minor things like, well, it's not always minor things, but mostly it's things like travel expenses or things like that you'd think, okay, we don't really need to cover that off, we can deal with that during the trial. But if there's no evidence written on it,
but sometimes quite major things like care.
Yeah, absolutely. Really, really important. You get as much evidence as you can on things like that.
And with those particular things, if it's something like physiotherapy, something like that, you can point at least to the invoice. But care, travel, that's wholly dependent on witness evidence.
Absolutely. Yeah, absolutely.
Client denies knowledge of matters in the statement. That happens an awful lot, I'm afraid. Obviously, if you've gone through the proper process, if the statement is in their own words, it will be hard for them to do that. But that isn't the way that statements are often prepared. Often they are prepared over the phone, and then they're written down, and then they're sent to the client for them to sign. Always check with them that they have in fact read the statement. It's not enough that you've simply got a signed copy that's been returned to you, because the number of times they will then turn around in the witness box and say, oh, I just got so many letters through, I was getting fed up, so I have to say I didn't read it, I just signed it, I got it back to them, I assumed it was what I'd said.
Yeah.
That happens with alarming regularity.
It really does.
And it's not enough for them to read through it 10 minutes before the hearing with counsel, because we always will, but chances are they are in a heightened state of anxiety because they're just about to go into trial, they're unfamiliar with the process. So even then, they're probably not taking it in when you do read it with them, not concentrating properly. And then again, the first time they really read it and reread it is when it's being put to them in cross-examination, and they suddenly say, well, I never said that.
Yeah.
And it's putting them at risk of an FD finding.
Absolutely. Even though they may well be telling the truth, or they've just forgotten something, or it was incorrectly recorded in the first place, but it's a huge red flag for defendants and judges. They are so much more likely to make an FD finding if they can point to a specific inconsistency between the oral evidence and the written evidence.
So the other thing I wanted to talk about is identical statements, and this is more what to do if, when you're given your evidence from the other side, you notice that all of their statements are identical. And that's happened to me quite a few times.
Yeah,
I'm sure that's happened to you.
absolutely. It's usually supporting witnesses who
Yeah.
they think it's going to be quicker and cheaper if we just give them a pro forma tick box and then we write it for them and they just fill in like a speed thing and they look identical by the time you've got to the end of that process.
But sometimes it can be even more than that. And so you have the exact same words. Sometimes the paragraphs will be in a slightly different order. So witness 1 might have it in paragraph 2. And then with witness 2, they've moved it down to paragraph 3.
It's so obvious.
Trying to confuse everyone.
Yeah.
So what to do if you have this situation? We've seen the rule. The witness statement must, if practicable, be in the witness's own words. But that's not a must be in their own words. So there's that little bit of leeway. Is it practicable for them not to be? But really they shouldn't be. So first of all, hammer the point home to the judge. The first case I had on this, I hadn't actually put it into a skeleton. I'd noticed it all. I took the witnesses to every inconsistency in cross-examination. And literally this case, the only difference is, so the witness, it was the foreman and his assistant. So the foreman had given his statement, and the only difference between the two statements was that his in the foreman's statement, he made no mention whatsoever of his assistant having been by his side throughout this entire morning.
Yeah.
And
then, funnily enough,
the assistant statement was exactly the same. It was just, I was there right by him, and then it was word for word identical. The judge in that case said in his judgment that the statements were somewhat similar, but found that they were still entirely reliable. So after that, I was like, well, that's not happening again. So now, I always put a table in my skeleton argument with the two statements written out side by side with the quotes. And this is a case I had. I've taken out any identifying information from it, but this was their statements and they were word for word identical. So once on the journey, I was aware that the defendant was initially traveling behind me. I mentioned this, and then he says, I was aware that the defendant was initially traveling behind us because he mentioned it to me. I was aware that the defendant would drop back and then speed up. And this made me feel uncomfortable. And then his friend, I was aware that he would drop back up and then speed up less than a car length behind us, which made me feel uncomfortable. Again, it was the whole statement and it just went through. But where it's in, where the judge can see it side by side, and again, you still do it, you still, well, the best way to do it is ask for the witness to be out of court.
While the
first one's giving their evidence, so they're not totally aware that their statements are identical. And then you can start your questioning by saying, you know, how was this taken? Is this your own words? Is this your account? And they'll say, oh yes, it is my account. Obviously they'll say that.
Yeah.
And then you can ask,
and you just
how
take
it was. You just take them
painfully through each of those.
And it was quite fun.
Yeah.
Excruciating
Absolutely.
at the same time. And ask them to explain it. I think in my case they were saying, oh well, it's because we were there at the same time. But it's like, how does this exact thought occur to you?
Yeah, absolutely.
And then after you've done that, there is a helpful case. There are a few helpful cases, but this one was the one that helped me in my most recent trial where this happened. Smith and Newcourt Securities. It's actually quite a famous case on fraud to do with shares and all sorts of complicated things, but you don't have to worry about that. The point in it is that there were two witnesses who had almost identical statements. They denied making them together. They said it was a sheer coincidence that their statements were word for word identical. But the judge said, and it was, as I said, it was a case involving fraud. So the other side's honesty was, he was
at the forefront.
At the forefront. He was accused of being fraudulent. And the judge said, in the circumstances, it would, in my view, be unsafe to make a finding of dishonesty against Mr. Roberts on the unsupported evidence of Mr. Lewis and Mr. Abrahams. Little, if any, weight can be given to their evidence when it's in conflict with that given by Mr. Roberts, because it was word for word identical. So, and the probability of that actually being their own evidence and not something that they'd come up with together was is, exactly. So it's well worth having that case and being able to take the judge to it.
We've got a couple of questions. So Lorraine, first of all, hi Lorraine. What if the client can give, oh no, sorry, we've done that one. Mataha. Is it possible to serve a second statement if the first statement has been very poorly drafted, brackets by a predecessor, or is it too late after mutual exchange?
You have to make an application.
You would have to make an application, and I would be mindful of the fact that a second statement which differs in substance from anything in the first statement is likely to call into question the witness's credibility. They might have a very clear explanation, which is, I didn't remember that at the time. I wrote my witness statement without the benefit of my medical records or the medical report, and when the statement was sent to me, I didn't have those documents either, so I couldn't include this information. I now want to include it. I think an application like that would be looked on favourably, and you wouldn't pose any difficulties. Similarly, if it failed to comply with the formal requirements, again, although it would need an application, I think that would be fine, just to make sure that it's got the proper statement of truth on it, for example. But if it's changing the account significantly, the two statements will be put to the claimant or the defendant, and they'll be asked why their account has changed. And I think that can be problematic. If you've already served the statement, then it's going in.
But that said, if their account has changed and they're telling you that the original one is wrong, then I think you would have to make that application. Because otherwise it would be far worse for it to come out in cross-examination and for them to say, well, I told my lawyers it's all right.
Yeah, no, absolutely, absolutely. So yeah, I think you can create a second one. Just be alive to the fact that you'll need an explanation for why the first one was so poor. And then we've got a question from Gray. Witness made and signed a statement prior to neurotrauma, but subsequently cannot recall events or statement. Would court allow this to be admitted? Yes, we see cases quite often where people have to rely on evidence either created contemporaneously to the accident or created earlier in time, and they now don't have the capacity to either remember or to articulate what is in that. Yeah, those statements will be taken into account.
Yeah, they'll be admissible, and it would be a matter for what weight the judge decides that they can place on.
Yeah, they would definitely go in, and then as Laura says, it's just a question of how much reliance is placed on that by the judge. Great, I think that's both the questions. So just to finish up, and feel free to fire any more. Question from Ian. Do you have any suggestions when taking statements from young children? So, I mean, I have not come across any situation where a child has had to give evidence themselves. If you've got a infant case and it's the child that's been injured, it's the litigation friend that's going to be drafting a statement on their behalf, both in respect of them accepting the amount of money that has been agreed between the parties, and also understanding the consequences of settlement, all of that sort of stuff. Have they recovered in line with the prognosis? All of that will be covered by the litigation friend, not the child. I have not, outside of family and criminal proceedings, where very specific rules apply to children giving evidence, I have not seen any civil matters where a child has given evidence.
I haven't either.
Ever. There are specific provisions in the family and criminal procedural rules for achieving best evidence with children. It usually involves them being videoed out of court and giving their account to a kind of sympathetic or impartial adult, often a police liaison officer who's trained in that sort of thing. But I have not encountered any situation in which a child has had to give evidence in civil proceedings. I'm just trying to think of any odd example where they might, but I can't off the top of my head.
Yes, a copy of this recording will be available on, I think it'll be online actually on YouTube, won't it?
Yeah, we've got our lovely helper Sophie, who knows about these things much more than we do, but I'm sure she can arrange that because it is being recorded. We can also send out the slides if anyone wants to see those. Sophie's got those via email.
Yeah. So we've had a comment, children are fairly frequently witnesses to liability and accidents involving the school bus.
Haven't done any of those
No,
myself.
right. I think the most I've had is a witness statement from a teenager, so it wasn't a young child.
Yeah, I think I've had children as such who were children at the time of the accident, but by the time they write their statements, they're actually technically adults.
Or someone who's been sectioned.
So if you have someone who lacks the capacity to be writing their evidence or conducting litigation or acting in litigation, then they probably need a litigation friend, in which case evidence can come largely from them. If it's someone who's been sectioned temporarily, so they did lack capacity and they've regained it, there would be no reason I can see that they
would be a
wouldn't be
fluctuating issue. So as long as they have
to
capacity when they're writing it.
Yeah.
I'm just trying to think, like with capacity issues with adults, I mostly deal with those actually in cause protection hearings rather than civil litigation.
Yeah.
But normally you wouldn't have a statement from the individual themselves. Normally it'd be someone will have gone to see them and will be giving a statement of an interview that they've had with them and of their expression of events and feelings, but it would be, the statement would be from someone else.
Yeah, absolutely. Jana, I had a case where the claimant was sectioned and upon being discharged lacked capacity. The litigation friend gave evidence through the events. Yeah, that's a very common circumstance. As Laura was saying, the litigation friend is deemed to be acting in the best interests of that witness and will give the evidence that that witness wants to give. So Ian says, I'm thinking of someone who has capacity but is in a secure unit due to schizophrenia. I mean, depends how long they're going to be in there. If they're in there long term and you can be satisfied that they don't have capacity while they're in, but if they do have capacity.
If they have capacity, then there should be no problem with them being able to do a witness statement.
Yeah. Even if you have to correspond with them sort of while they're in the secure unit, they can still write their evidence down or give it to you over the phone. I don't think there's any issue, but obviously you'd have to be quite careful that you are happy that they do have capacity.
And also that they're then able to give evidence, and you'd have to be making arrangements, presumably.
For them to do that. Yeah. I mean, the courts are fairly good at setting up video links, particularly if it's a combined court centre that deals with magistrates' hearings, because they're always dealing with people from custody on live links, so they can set up that sort of thing. I think that's it from the questions. Yeah. So just some kind of things to highlight to wrap up.
Oh, do you know what? There was one question that we did miss.
Oh,
earlier,
sure.
Which was, hang on, who was it? Mutterhouse, are some defects less serious than others?
As in, I mean, yes, in terms of, I mean, I think if you missed off the header, you wouldn't bother to file a second version of the witness statement. But if the statement didn't have a statement of truth, then you would definitely file a second one that made sure it had a statement of truth on the bottom. So yeah, I think some things are more serious than others. Thanks. So yeah, just some things to finish off. Read Practice Direction 32 and Practice Direction 22. 22 deals with statements of truth, but it's linked to 32, so make sure you've covered both of those off. Make sure the witness sticks to the facts. They might be tempted to go off on a tangent. They want to get everything that they want to talk about in. Don't let them. The judge just wants them to deal with the issues in the case. Don't be tempted to include law. Don't be tempted to include argument or commentary. All of that is the barrister's job when it comes to submissions. Make sure that you're covering all the issues, including difficult things like inconsistencies, as we were talking about before. Deal with them head on. If there's going to be an issue, better to deal with it in the statement. And then, as Laura said, just make sure that they know what their statement says before they get to us, because by that point, it is a little bit late. If they're going to deviate massively from their statement, then you're already in trouble before they've even begun, really.
And Jenna, just regarding your questions at the sort of beginning of the seminar, the provision of the CPR I was thinking of is 3219, which is your notice to admit or produce documents. It says a party shall be deemed to admit the authenticity of a document disclosed to him unless he serves notice that he wishes the document to be proved at trial. So although it doesn't actually say that the records themselves are necessarily accurate, at least if you've disposed them already, the other side are deemed to admit that they are authentically the council's records. And really,
unless they take issue with it,
I think that the court should be assuming they are.
Yeah, I've never come across a case where a judge has just of their own volition decided that
some
something.
judges do go rogue.
I mean, yeah. If this job teaches you anything, it's that there are no guarantees when it comes to court hearings, and there are always some surprises. Some
Dennis said maybe they
better
were in
than
a bad
others.
mood.
Yeah, exactly. That could well be the case. Unfortunately, we've all come across judges who are clearly having a bad day.
I think 3219 does help you out, because at least they're saying, look, it is that no one's challenged it, so we can at least deem it is an authentic document.
Yeah.
And really, why would the council's records say that this person's an employee
when they're not?
When they're not.
No, exactly. So everyone, thank you so much for your time. If there are any more questions, then do let us know. And if you've got anything that springs to mind afterwards, then feel free to email Sophie, who sent out the link to all of you. She can pass them on to us and we can certainly get back to you. We'll make sure that Sophie has access to the slides and the recording. So if you'd like those, then
I think in fact Sophie's commented that she'll be sending it all out within the next couple of days. So
marvellous. Thank you, Sophie. Who is listening. Thanks so much, everyone, for joining. And we will let you all go unless anyone else has any burning questions. No, I think not. So yeah, enjoy your evenings, everyone.